they have made it mandatory. And we have other one. Another one is digital forensic investigation. So as the evidences, as the digital evidences are made as primary evidences, I think bringing up the digital investigation process mandatory so that there is no fraudulent activities are taken.
Coming next one.
Good morning, all. With the purpose for a victim to approach a court of law, it's like okay, just immediately. We have to have some remedy in the right to self-defense. So as a part of it, when discharging a case earlier, it was just the prosecution side and just the magistrate. If they are satisfied, they'll be able to withdraw the case. But now the opinion of the victim is put on, like it's a good thing. The opinion of the victim will be heard at first. And another thing is with respect to order of maintenance. Under section 145, earlier the place of initiation of proceeding for a father or mother who is seeking compensation from their child. The place of initiation of proceeding was just the child's place. But now it is with respect to the father or mother, which is a welcoming change, which I feel.
Thank you. One more.
Sitara. The question that Sir asked was there a real need to bring new criminal law, especially a procedural law, from CRPC to RP and RX? I would look at it as both symbolic as well as a practical need of the hour. The symbolism being that we really wanted to come, Stephen James and Macaulay's time to come a long way after 7 decades, time to dust off the colonial remains, whatever left behind to come our system. Laws made by Indians for India, and the practical aspect being that we have changed. The digital era has come in. Digital penetration in India, out of 1.4 billion population, we have over 1.1 billion now mobile users. So evidences and electronic, electronic recordings to be used in the procedure. So a lot of changes were required, and an overhaul was really, it was time for an overhaul in the our traditional, criminal laws, which was not much needed. So I think this is an attempt by the current disposition to bring forward, which will take time to get into our system. Anything new takes time. There will be deliberation, debates, judicial reviews over the time. 10 years down the line, we will be sitting here and maybe we are looking at it.
Thank you.
So, good morning, everyone. This is Franklin here from final year. Yes, of course, I want to quote, first of all, I want to quote Justice V.R. Krishna's words. Procedure is the handmaid of justice, meaning that procedure is to serve justice, not to hinder justice. Firstly, that's what I want to say. Another important aspect which Sir asked is the change which have included in BNS system. I think so. The most important inclusion of ex parte trial. The trial can be taken place if the offender is not even present. I mean, the party is not present. The ex parte the trial may be taken. This is a very important, important thing to discuss. We may come across ex parte trial in CPC and in civil aspects, but as the criminal case is concerned, is ex parte trial is very important or not? It's very important discussion to take place. Yes, I want to open the discussion. That's it. Thank you.
This is anyone we can go or we can go into specifics. Okay. Anyone? Right. Let's ask this question. No. One of the very first or most prominent change that has been put forth is the streamlining of judiciary. Streamlining of the judiciary. What they have done is they have removed certain courts and the stated objectives where to make the justice more streamlined or modernized, where people can go and approach a court of law and a limited number of appeals and other things. Okay. Now, You tell me whether taking out the Metropolitan Magistrate course and the Assistant Session Judge course is really something which was necessary, or that could have been just left as such. Yes, anybody, please. Yes, please. Yes, please. The streamlining of duties, they have removed certain courts, right? Section is the same, but they have removed certain courts. Some courts are not there. We don't have the Metropolitan Magistrates, we don't have the Assistant Judges. Do you think, has it really streamlined, or was it something necessary? Yeah, if you are ready, then somebody is ready, then you can speak. No issue. One issue, one time. That's right. One issue, not twice. One issue, definitely.
Thank you, sir. So, like, as you address the question now, like streamline of judiciary, according to my point of view, the changes that has been made in BNSS are actually streamlined the judiciary. I would say, like, more point of view that came up when such provisions have been inserted was that, again, the courts will be burdened with a lot of cases and all. But I would say there will be a clarity of jurisdiction, sir, firstly, and there won't be a clash in or confusions when the common man approaching a court. And I think that is the one betterment that have been procured through deploying such a provision in VNSS, and it has actually streamlined judiciary. Also, like I would say this is an effective measure because there won't be any, there's a clarity of jurisdiction now as such. So for that purpose, I will comment. Thank you.
Okay, thank you. Any other question? Then I can pass the mic.
Very good morning to Madam Cecilia. I am coming from final year. And the thing is, for what purpose we have just implemented the ADRs, alternative dispute resolutions. The main thing is to reduce the burden of the courts. So, in the sense of growth of the population, the crime also is to be increasing day by day. Whether the courts can tolerate or manage everything, it can be. That will be a time delay to take the files, to move the files. Everything will be taken. So, this streamline is meant to be not to be changed. This BNSS has been changed, but it is not necessary. For what purpose the ADR has been made, but in all the cases has not been taken into the ADR. So we need much courts to be implemented when there is a rise of crimes and rise of as much as there is a digitalization, the crimes also in digitalization is going to be raised up. So the crimes has been increasing more. The courts to deal with this or has to be increased to be more, not to be decreased or to be removed. So it is an unnecessary change in PNSS as per my point. Thank you.
Only one more. Only one more. So then we go to the next one. Yes. Thank you, Pastor.
So as far as the question is concerned, the streamline of judiciary, I don't think so because the Metropolitan Magistrate is not taken off or removed. He has been again being acted like a judicial magistrate. That's they are not completely removed. What my fellow sister has said about burden of cases, it's not like that. Actually, the Metropolitan Magistrate is getting converted to again a judicial magistrate. Only the seal and signature will be different, not so. And as far as the ADR cases is concerned, it is predominantly deals with the civil cases, not with the criminal cases. So I don't think so. The number of cases might get increased. So that's it.
Anyone? Right. I don't want to correct anybody. Right? It should be a discussion between you people. I'm just here to throw the point. Right? Again, ADR is possible in criminal case only for compoundable offences. If you have compoundable offences, ADR is possible. You can still go to a local analyst and compound an offence. It is still possible. Other than those, I think criminal cases in ADR is not possible. One. And then Streamlining of judiciary, in a sense, what I wanted to ask you was, there are courts in various countries where they have court of initial filing, an appellate court, then the Supreme Court. Finish. One, two, three. And they will not allow the people to go from court to court for appeal. And this is what they wanted to achieve. The question was actually whether they have achieved or not. Right. We'll go to the next one. The arrest process. The process of arrest that was there in CRPC, I don't think there was a sea change, but still there are certain changes that you can see in, between CRPC and PMS. More particularly regarding use of force and the use of restraint. Use of force and use of restraint. I think you must understand what I am telling. Right? Tell me whether it was necessary. I mean handcuffing. BNSS allows handcuffing. While CRPC and the Supreme Court have time and again said handcuffing should not be there. Now BNSS has put it in black and white that for these cases handcuffing can be done. Do you think it is necessary? Do you think it is acceptable in this civilization? Yes.
Handcuffing is for the offenders who has offense multiple times. And also for certain offenses where the crime is so serious. So I think for that case, handcuffing is necessary, but still it contradicts with the Supreme Court ruling. But we have mentioned that certain offenses where the offender does habitual offenses, handcuffing is mandatory. I think. But
Anyone please? You think handcuffing should be allowed? If you see the provision, it says that even producing before a court of law, a person could be handcuffed. I believe that is what the provision says. Yes. Please.
Not according to Article 21 is against humanity also. Because handcuffing a person is like demotivating the person. And it's like making a serious crime. The serious crime is all just escaping from the serious crime is all escaping from the crime easily, but when it is people or normal crime in this more case for primers or just handcuffing is not
Right, thank you. Thank you.
When the handcuff is required, right? When the person who is arrested is capable of causing harm to himself, like hitting against a wall or something, or if he is capable of causing harm to others, if that is the case, or if he is trying to escape, only in that point of time to just detain him in the custody, maybe the handcuff was used earlier, and the Supreme Court has time and again held the same in multiple cases. But now, when we say like we are listing a set of offences, like these are the offences, those offences can be out of grave and sudden provocation, or they might be feeling bad, like why I have done so much things. Like, not in all cases, but in few there are causes. So if we are not considering them, and just like that, on the whole we are covering like a handcuff can be used as against the accused. It is not that proper.
Thank you. Yes.
So, like as my fellow maybe quoted Article 21, I would say that this has to be viewed according to Article 21 per se. Like Article 21 has specifically mentioned that no person shall be deprived of his right to life and liberty except by the procedures established by law. So the law has established a procedure, and judicial review has also not come up with any contradictories as such. And I don't see this as cruelty or something to or a inhuman treatment to the accused person. It is just a process. It is just a small part and parcel of the arrest process that is actually necessary to confine the person. That too for specific offences they have mentioned. So I think there is a clarity with the legislation as well as the judiciary will also have the same clarity when interpreting the same. So yeah.
I believe the judiciary will have its field today, right? It will go to the higher courts, the High Court, Supreme Court, then they will interpret it in their own views, and they will set a guidelines on how these things can be done. So then we'll have more clarity on what they are. Then we'll go to the next one. Right? We'll get to the next one. Now the process of FIR, other things also. First of time, you have to go for other laws also. The process of registering and first information system. And again, that is one of the key highlights that is protected by everybody. Again, somebody who supports or somebody who says that it's a very good law is the process of making the registration of FIR easier or more public friendly. Right, you tell me whether the process is actually there. You tell me as to whether the process will be actually beneficial to the people. Yeah.
Like I welcome this fact of e-filing, sir, because being an individual, we always have an issue whether we can approach the police station, whether we face them directly. These are the issues we face normally. So if it is e-filing, it will probably convenient for people to do it online, and probably it's needed that uh, we need to go after 3 days and we need to follow the registration
Within 3 days.
within 3 days. So,
Yes.
I have a point here. We are telling like it's EFIR, we like give information to electronic modes, that is not fine. But after 3 days, we expect that person to appear before and you are asking
Within 3 days.
that is within 3 days.
No, after 3 days, if you go, the information will no longer be there. You should go within 72 hours and get sign the document, then only they are registered there. If you go on the 73rd hour, then you have to give information again.
So that is the thing. I think that's not proper in the way. Like the need is immediately you need to address. You want some issue to be addressed. That's why only you are just giving it. And when you say for registering of FIR, it will take around 3 days. There need to be some consider.
Yes. And he wanted. Okay.
My point, it's, e-filing, it's 50-50 part only. Because nowadays, filing a case is like just going and buying something. If me and my fellow mate have just a fight with each other, they'll just put in FIR. It's an unwanted burden for the ourselves also. And that filing appearing within 72 hours, 50% people only just going and appearing. 50 are like just they have a sudden provocation, they're just filing the case, and then after that, oh, okay, this is my brother, this is my friend, so just I walk out from that. It's, on my point, just a 50-50 for us.
So basically, you are telling me that 72 hours is to give the person time to think whether he wants to go through with the process.
No. Yeah, it was like it's not. They are not making the FIR a valid thing because the FIR is it itself has the first information report. For the e-filing, they are just giving the report because of the just they have the sudden provocation only. They are putting an FIR. After the 72 hours or after the 2 days, they are just like, I don't want to be part of the case. I don't want to make any bigger issues. And within the 72 hours or within 1 or 2 days, the matter just got sort of. So that filing e-filing affairs.
So, yes.
Sir, this e-filing, as far as concerned, I would say that this particular provision as Yeah, it will never allow room for I think the legislation has been very strong to that point that they have to make the work easier to the people that is to the common man that they can file the FIR through the e-filing process and they can make it easier as simple as that. The main point that is there in legislation intent behind this has to be viewed as such. It is mainly concerned that they cannot be room spoiler for reasonable things that they come up with during the court proceedings. That is, they say reasonable grounds they come up with and say they justify their delay in filing the FIR. Now, those grounds cannot be given by the person who delayed in filing the FIR because the work has been made so simple by the legislation, and I think. Yeah, maybe after a few days of this process working, we can figure out whether it is actually effective or not. But according to my point of view, it is actually effective because though they have to appear within 72 hours time, I think this is actually effective so that they won't come up with any excuses or something for the delay that they caused in filing the FIR. So that I would say it is effective.
They mean that it will help the affected person. They can have a paper trail or a digital trail that when they get the information, when it was received, so that at a later point of time, if the thing is done, they can take the police to task.
Yes, yes.
Yes, sir. Nobody's talking about the zero FAR. So start it here, please.
Two very positive improvisations brought in by BNSS. One is zero FAR, the other is ZFAR. Zero FAR, any jurisdiction, regardless of the jurisdiction, one can file a FAR in any police station. Yesterday, there is a news case of a 8th standard child in a Dehradun boarding school being sexually harassed. The father is the son of a retired police officer belonging to Sikkim. So he has filed Shillong. Sorry. So he has filed the FIR in Shillong, and though the offences happened in Dehradun. So this facility is very beneficial to the layman that he can immediately approach any police station and file an FIR, and later it will be passed on to the Dehradun station. Then EFIR again. Imagine everybody can send an email and send an information. How credible is that? Any informant can send a mail, maybe anonymous with burdens system. So if you're very serious about it, you have to follow it up by coming in person to the police station and putting your signature and say that you meant what you said in the email. So email as an electronic medium, provision is given, but it should be followed up with a credible in person. With the signature. So there's two aspects of EFIR and zero FIR. I think eventually it is meant for as a blessing for the layman. It's beneficial for them. I think so.
Thank you. Aaron? Yes.
So it has been said that it has been said that in section 33 of PNSS or CRPC or earlier also, that a person has to inform of certain offences to the police, or he has to take to the police or to the magistrate. Now, having fixed a time that he should come and confirm that it is he who himself have given the FIR is something to be looked upon, because just by a person giving information does not amount to be considered as a police offense. So it is the police officer who is going to take it up. So anybody giving information need not actually feel that his presence is required. First thing, if he insisted, if he has an option of thinking and saying, I need to know in furtherance of what happens in the case, I need to know, that would have been better than fixing a time of 3 days to come and affix his signature saying that he has given the information.
If it is not the victim, but if it is somebody who is aware of a crime,
Yes.
gives the information, that person should not be called, should not be forced.
By the section, even if he is not reporting it, that itself is an offense by this act or the code. It says that it's a right for him to do it.
I understand your concern there. But if you see those provisions, have you ever seen anybody put under those provisions?
No.
Well, it is there. It gives a positive duty on every individual who is aware of anybody having a design to commit a crime to inform the police. Even I believe many how many of you have done CRPC or BNSS, those provisions would not have been taught to you. Even the teacher would just skip it and go. They'll simply skip and go because those things have no practical sense. It makes sense on paper, but in practice, in a country with a 140 crore population, and anybody who does not inform about a crime is going to happen, and they have unless they are collaborators, or conspirators, then that is something that is there. But I take the other point where somebody who is not a victim, he just saw a crime take place, he sends a mail to the police that this has taken place. And it is for the police to go to the crime scene and see whether something had taken place, somebody victim is there or not, and take upon themselves the cognizance or FIR or whatever it is. And the person should not be forced. That I take. But I will accept. Yes. Yes. Yes.
Yes, actually, for instance, for example, let us say that in rural areas, any crime happens, the particular victim or victim's family is afraid of local police station. They can give to a complaint to any other police station for Honorable Justice Chandrachud Court. Unless the infrastructure is being developed, the three criminal laws will not be effective. It is also applied to this zero FIR, EFIR concepts as well. Actually, so how can we say, again, we are saying that digitalization, how can we say that it is a full digitalization of the procedures and other things as well? That's it.
Thank you. Yes.
So
And the mic, and the mic.
this is right. I talk about
Yeah.
if I'm not wrong, the CRPC already allows FIR being filed by writing vectors. If that as a point is that, why by filing EFI need to be present? But if you're writing the post, it clearly states that the police will investigate. If there is a case, properly they will investigate through it and take action.
And what is the process in CRPC for FIR? Is there any provision for sending information through post?
The answers can be given through post.
I will take it into you, or no, again, people should have it, not me, right? The discussion between you, what, yeah. In post, you have signature. In me, you don't have signature. Maybe that is what they will say, right? Anything else?
For the EFLs, the process takes less time. Post would take a lot of
No, what he is asking is, when somebody sends a post to the police station, disclosing information regarding commission of offence, it may be either named, unnamed, or pseudo name. Can be named, unnamed, or pseudo name. If that is the case, if the police investigate, or if the police starts the investigation and if they find something actually has taken place, even if nobody comes and signs or claims as FIR or given the FIR, the police will continue. Why do you want the EFIR to come? That's what is that.
like what I'm saying, the post might take a longer time. Whereas email would take a lesser time and it reduces the burden of the person who's giving the information.
Why do you want him to come in person? It is same as what she had asked, right? If somebody gives an information, you go upon the veracity of the information. You check. When the police check if something is really wrong, let them take it up on themselves. And if they have found that there is something wrong, let them investigate. This one. And maybe that signature part there is to prevent the police from going on a what it is, ghost hunt. Basically, that is that. Going on a ghost hunt. Ghost hunt in a sense, you may receive 1,000 emails, right? You may receive 1,000 emails a day. If they have to go and investigate every email, some real crime or somebody who is really in need, that could go under the sheets or that could go under their radar, right? So the process would be again EFIR is good. Again, I don't say EFIR, I will say e-information. The correct term would be e-information. You give the information electronically. That information is recorded in paper only or whatever computer system that they have. It is not like you give an information, they record it electronically. Electronically, you cannot make it appear. They will do it upon themselves. And by post, in CRPC, what we had was like either you go and you say that give the information orally or in writing. Whatever you have said, either orally or writing, you sign that. If you say orally, it is in writing, signed by the person. If it is in writing, it will be recorded in the appropriate register kept by the police as per the rules of the concerned state. And the signature of the person will be obtained. This is what the procedure says. So, if it is oral, it will be reduced into writing. If it is written, again, both statement, whether it is oral or written, has to be transcribed in a particular form. And this person's signature can be got in that. That is what they say. Even if you send a post, they will ask you to come. They won't do it without your process. They'll ask you to come. Yes. Hey, we have 2 more laws to cover. I think our deadline was 1 o'clock. Right? But still, I will just end with the last one. The most sought after thing that everybody was talking about the digitalized version of trial. This validity to electronic medium or through digital medium. Tell me whether it can really be achieved in India. Anybody, please tell me. Is it really possible in this day to do, again, recording statements, even recording witness statements, so many things. If you see the last one question, they talk about validity to process that takes electronic. It does not say that the process should be done electronically. It is up to the judge to decide whether to allow those things or not. But if the judge allows and takes the statements, then that is valid. It does not say that it should be done. If it is done, it is valid. Yes. Yes, please. I'll throw one scenario, right? You can examine witnesses electronically or through video conference, right? You don't use a 360 camera, we don't know what kind of a camera that they're using. There may be somebody threatening someone on the background. And if you don't say these things, I will cut this person's head. You don't know what they are saying, right? There is no process set forth in the BLSS to ensure that the people will have safety and security. You are allowing an important witness to give evidence electronically. And somebody is standing right opposite there, behind the camera, holding somebody hostage. And this I have not seen anything. How do you do these things? Yes, sorry. We are jumping the gun and just throwing some masala into it. Yes, please.
Sir, firstly, the question which you addressed, whether it will be possible for implemented successfully. So I think into the COVID period, which we were in that, I think no courts were struck down and no the entire criminal justice system also did, in the 2 years of time period, everyone got struck down. Like all the commodities, everything got struck down. But then too, the criminal justice system was working as such. I think day and night they were working like as usual. I think they didn't have any curfew or something. And when coming to the point that whether India will be able to culminate it successfully, India has already done it, and it has already shown that it can be culminated very successfully. That was the situation which we none of us anticipated, that we all would be in curfew, and we all we cannot even step out of our own house. And even in that circumstances, all the court proceedings were happening, and I think that was a trial basis India was actually taking off, and based on that, I think they will culminate it successfully and take off. I think it is just July 1st they have implemented. If at all it takes a year or more, we would obviously be talking about its effects, and yeah, as we are talking about the COVID period, that's
It
what.
will take at least 5 years, 10 years to know whether immunity.
So we have asked the state government to give guidelines
Regarding witness protection.
regarding how to take the evidences in the audio form and video form, how to present it, what is the mode that they want to do it. So it is yet for the state government to come up. So only after that, we will be able to understand what it will look like.
Maybe the most logical way would be where you set up centers everywhere. I may be in Kerala, I may be in Karnataka, I have to appeal for court in Pondicherry means I should go to a court in Kerala. There must be a room set up where I can go and present. And that could be recorded, and somebody must be present to ensure that it is being done properly, and it could be recorded somewhere. Or it could be recorded like witness, digitally telecasted in the court where it has to. Something that kind of setup is done. Where you can ensure that there is a free and the person is free from threat and fear. And whatever they are giving is something that is what they wanted to tell. Okay, we have to wait. We have to wait how they are going to do that. If you're going to allow people to sit from their home, and we know what happened in again, what I was telling you during COVID, we know what happened, how people attended office, how people attended things. And there are cases where people, advocates attending both with cat face. All those things are there. Let's see what happens. Okay. Yes, please.
Yes, sir.
Because I am winding up. I will hand over to Professor Kaushik Pratap Singh to be BMS, and he must be outside. You can call it, right?
Yes, regarding the point related to COVID trials, we don't have, of course, if I am not wrong, NGDS keeps the record of judiciary. But we don't have exact data on how much cases were conducted trial during the COVID. How many cases were convicted, how many were acquitted. We don't have exact data as far as the COVID time is concerned. So we can't say we have already gone through the electronic trial. So it is it may become a nightmare as far as the electronic trial is concerned.
Yes. Any events? What do you know what they did in COVID time? Most of the prisoners inside the jail were either given bail or they were sent on leave, sent on furlong, sent on parole, all those things to prevent the overcrowding inside prisons. And civil cases were conducted what do you call that, through digital forum, through web conferencing, web method. Criminal cases were literally stalled. That is not possible, literally stalled, because for a judge it is more important to see the witnesses' body language, how they speak, what they say. It is not just the words that they say. Judges see so many things. Right? Even an advocate who is going to cross-examine, he will see the witness, not just hear the words. So it is something that we need some personal touch. One. And then what COVID has actually done is COVID has improved the infrastructure in the courts. The courts are equipped. We have a system in place in the courts where they have systems and softwares and the proper stable internet connections to make sure that they can do this process via internet or like via these mediums. So this is what it is. If you have anything else you can talk, or I will hand over to Kaushik Pratap. Yes.
In the face of a pandemic again, what should the procedures be? Why is it not addressed in or any section which says that perhaps this should be all the
Because we don't know, we might face another pandemic, like, there are chances.
You may face not one, you may face
Many
many.
more.
But that is why we have that last one saving clause, right? The saving clause for digitalization is, I believe it is for that. Not specifically for that, it will also cover that. So even if you do those things digitally, it can be. Okay, right? It has been lovely interaction. Sorry, last comment.
My humble question to you, as a professor and as a point of view of yours, whether it is safe and secure for the women or the girls under the age of 18, this for as a victim, this method is safe and secure. I'm asking of your point of view.
If you take the law in total, I believe if you take all the three laws together, there are enough provisions in place to ensure women's safety. There are enough provisions in place for recording of information. Even in FIR stage, if somebody is giving information regarding a sexual assault, I know, though it is not a part of the registering FIR, the statement of the woman should be recorded by a magistrate. It is there. Right? It is there. And there are other things. This question is also there. Right? And even if the woman is not in a position to come, the statement recorded by the magistrate would be a substantive piece of evidence. Right? It is there, but we have to see. India is not a country which is suffering because of lack of laws. India is not a country which is suffering because there is no law on a particular point. India is a country which is suffering because people are not implementing the laws in its true letter and spirit. Right? Our country has thousands of laws. If those laws are implemented in letter and spirit, then we would not be in this position. We don't lack laws. We only lack the will of the people who are implementing this. Okay, thank you. It was lovely speaking with you. But I want more people to speak. At least maybe for BNS, others will speak. For BSc, others will speak. Okay, thank you. I will hand over the mic to Professor Kaushal Pratap Singh. He will take care of BNS or the new IPs. Right. Thank you.
Thank you so much.
Thank you, sir. A very good note to one and all present here. And myself, Kaushal Pratap Singh, Assistant Professor in Law, Dr. Ambedkar Government of College. And I'm here to take the session on BNS. Okay. So I heard that you have a good interaction about BNSS. Now I'm going to take the BNS. So, like, background, already you have discussed regarding the new criminal laws and all. Now, directly, I want to know your opinion, your point of view, that really there was a need of new BNS 2023, like we have earlier Indian Penal Code 1860. Now we are having Bharatiya Nyaya Sanhita 2023. So, what is your opinion? That really we are in the need of having this new criminal law, new BNS, or older one was sufficient to tackle the present situation of India. Okay, so just give me your view only first. Firstly, Chadinar School.
Good morning, sir. Sir, so the question that was raised by you, like whether it is actually needed, that is the changes one has been made and now we are having as BNS. I would say there has to be a rejuvenalization process in the criminal justice system per se, but then the law that has been implemented as far as concerned is not that very sufficiently covered the very purpose of the rejuvenalization. So I would explain it why, because there have been a lot of good provisions. There have been a lot of good provisions that has been added upon, like for example, typical blue collar crime that has not been addressed timely. That is snatching has been defined under BNS now, and this is a very good thing. And there are a lot of there are pros and cons in it, but I could figure out a lot of negative things in it, which was not just me, but a widespread concern as such. Like, yeah, sir. So the adultery has been held unconstitutional, and then when they strike off the very purpose of Section 377 of old IPC, unnatural offences, which was actually giving.
I want to interrupt you. Like already these provisions are declared unconstitutional by various cases. Like you can take the example of Joseph Shine.
Yes, yes, but
So adultery was struck down. Then after if you talk about 377, now this Johan case was there. Honorable Supreme Court has already struck down. But still we need to give BNS.
Yeah, that's what I was about to say, sir. So Joseph Sign case and every other legislation like Supreme Court, wherein they are very clearly the judiciary has given their stand on this 377 as well as for the adultery cases. But then my point of view is that now the lot of concern coming up for the LGBTQ community and yeah, the vulnerable, they are becoming more and more vulnerable as even the Supreme Court took the stand that they're not going to bring in laws for them. Yeah, in last year's judgment also, like they have quoted the same. So when they're not going to recognize their marriages as such, that is the first place where their rights got hit. And I would say this unconstitutionality, which was already held in those judgments, when the new BNS enacted, when that took up those stands by the judiciary and they enacted the same, I think again and again the LGBTQ community is becoming more vulnerable. As such. So that was a thing I was about to say, and also insertion of terrorism definition in BNS. That was also a point where I think there will be an unnecessary confusion because they have also mentioned that the superintendent of police have been having the power to decide whether to take the cognizance of the case, whether in Unlawful Activities Prevention Act or under the BNS provision, which is talking about the terrorism. So I think when already there is a special law providing, providing for this particular thing, that is terrorism. Why do we need to have a repetition in a common criminal law, major law? So that is what is the thing which I want to talk about. So I think 70% of the old law just remains same for the BNS. The small changes also, I think there are certain repetitions which could have been avoided. Just as a point of view, I am just saying. Thank you.
Another one from APLC.
I think the changes made in the BNS is important because over the punishment for over 83 offences has been increased. It is practically impossible to go and appeal each section by section, to increase the punishment in each section. I think by enacting a new law, the punishments, whereas the imprisonment period has been increased, and also the fine amounts has been increased, and even when we're speaking about the fine amounts, even when we speak about the fine amount, I think the fine amount that was already in fact already been there is so less comparing to the economical value of the India now. So it is one good point that increasing fine is valid, and also speaking of the offences against women and children, it has been organized. Whereas it is easy for the layman to approach it. Whereas in the previous act, it is scattered all over the act with that one search. But now in the BMS, it is well organized and it is easy for the layman to approach it. And also, I think one of the negative that can be pointed out in the BMS is that there is no women person in the committee that is organized to enact this BMS. And also the crime of marital rape has not been bring up. it is not made as an offense. I think that's.
Sir, I think I'm audible.
Yeah.
I think IPC, Indian Penal Code, was always all about penalty, punishments. But now Bharatiya Nyaya Sanhita is always defined what justice. So I think this needs change. This change is needed. The next point is that now the last 10 years, crime is busy. We have been basic things, but in last 10 years, different offences are about lynching, terrorist attacks, snatching, petty organized crimes. I think this needs to be addressed now. So now DNS change is necessary. That's my point.
Okay, that's good. Like if you know, like we talk about like she rightly point out the name Nyaya Sanhita, what the philosophy behind that name. So this is another aspect we can discuss. The important thing is that the content of the law. Okay. So as per the requirement of the time, what as a student of law we should know that whether this is a peak time to have a new criminal laws or not. So if we go through Indian penal code, so that was drafted by Lord Mac. So the scenario was different at that time. And if you know the content of the law and society should move parallel. So at that time there was a need of that particular Indian penal code. Now scenario has been changed after so many years. Okay. Now, so if we see, like you can take the example, like you can go to the SP, there was a revolution of see, like you can take the example, like you can go to the SP, there was a revolution of 1857 there. Okay, so revolutionary activities. Okay, you want to say something with that?
My point was just the politician should be called. So coming to the punishment, it's before the on IPC, it's or fine or punishment. Now in the BNS, they are just implemented the fine. But regarding to the punishment also, that is not that much severe punishment for implemented. For the politician, they made the punishment which they can have the what to say, the politician made the punishment for us for them to do that. The petty case people can't have the death sentence, but the bigger right, people have the just paying the fine and having too much of investment and they just getting from the law. The changing of the IPS to IPC to BNS is because it's just a politician.
Okay, so I will come to your point when I will discuss the point of punishment. Okay, right now I'm going with the first scenario that whether it was need of the hour or not. Okay, I will come to the later on the point of punishment. Okay, so if we see like as per the requirement of the time, we must have a law. Like at that time, scenario was different. In order to curtail the revolutionary activities, 1857, in various parts of India, there was too much revolutionary activity was going on. So they drafted such type of law. For an example, the provision of sedition. Okay, Section 124A of Indian Penal Code. Now, like as per the change of the time, as per the change of the society, the law must also change. Law should not be static in nature. It should be dynamic as per the requirement. So, like we have advance in information technology, artificial intelligence. So we require to tackle this problem into particular that particular kind of law. So, like my view is that yes, there is a requirement of having a new criminal laws. Okay, like or you can see like new form of crimes we are observing in last 1 decade. Like earlier also there was a like snatching and all, but we are not having such type of law. And why we need such type of law? Why we need new changes in the law? You can take the example like every time amendment is there in any particular, like where in the constitution also. So like if you see the rights of arrested person, earlier it was not recognized properly. Now after the case of PK versus State of West Bengal, Honorable Supreme Court has given that guideline regarding the rights of arrested person. Now we have incorporated in section 41A, B, C, D in CRPC. Similarly, that you know that like in BNSS too, that we have a number of laws we need for implementation. Similarly, I'm agreeing with the point, but there are some situations on which we are not having law. So when situation arises, then in order to curtail the situation, we adopted the law. An example regarding this, any situation, particularly women. An example, earlier we were not having any law on that point of view, but after the situation arises, we have drafted the law, we have incorporated the law. Exactly. I'm talking about the era of IBC. Like Vishakha versus State of Rajasthan. Okay. Sexual harassment of a woman at workplace. At that time there was no law. But Honorable Supreme Court has given the guideline that these should be the guideline which every institution, every organization must adopt. Now we have Sexual Harassment Protection Act 2013. Okay. Now, similarly, if you go to 2012, November and December, there was an incident of Delhi gang rapes. Okay. Now, what happened? I'm giving the example that how law should be progressive, how law should be changed as per the need of the society. And it is the society which needs the law. So, what happened? Like the demand was raised in all over the part of India. Now, at that time, we were having amendment of 2013. Okay, again, the incident of rape was not reduced in the number. Again, there was a rape with the minor in Kathua, that is in Jammu and Kashmir. So again, we have amendment in 2018. Okay, now we have amendment. Now, see, like I'm giving the normal example, like during your childhood when you are studying the mathematics, if you are solving any problem, okay, if there was a mistake in one line, what you will do? You will cut that line, you will add. 2 line mistakes, you will cut and add. But what happens if you have to, out of 10 lines, you have to cut down 8 lines? So what would you like to suggest? That whether to completely shut down that act and shut down that position or that particular problem, and from the beginning you have to solve. What you used to do? Like whenever there is more than 2 or 3 mistakes during solving any problem during mathematics, in order to avoid the confusion, what we used to do? We cut the whole problem, and again from the ab initio, from the beginning, we start to solve this problem. So similarly, the need of the hour was that yes, we need a new criminal laws, and you know that everything is not perfect. There is some pros and cons. So no doubt we are expecting amendments in the BNS also as well. Okay, so this is about that we need a new criminal law at this present scenario in order to tackle new type of punishment. New type of crime. Like now, earlier what happened, there was a concept of currency, theft, and all. Now there is a concept of theft, but these things are done online. So we need provision like that. We need to advance the law in order to tackle this problem. Now, hope that for the second question, which I want to ask, I have already answered, but I want to take your opinion as well. That whether what is your opinion? That's my personal opinion that regarding shut down the problem, solving new as well. What's your opinion that whether amendment was sufficient to tackle the problem or really we need new laws? Amendment was sufficient from Chennai School of Law. Amendment was sufficient.
I basically view the BNS as just a improvised version of the IPC. So I don't really view it as a new law.
So you are talking about BNSS or BNS? BNS, okay.
So when there have been like major amendments to other laws, and there have been major amendments to other laws where like there was a huge amendment which changed like the nature of the laws. Why it couldn't have been for BNS? Because it brings up like unnecessary complications, and also there could be an issue where like an argument could come up in court where like the precedents which apply to IPC don't apply to BNS because it's a new law. That makes sense.
Another one. Any other people want to say something about it?
So the question is that, yeah. So the question is that whether we actually need this or not, or whether amendment however it's but I would say that the amendment is not that very effective. We need new laws because it is time old laws that has to be changed. And it is really good that at this point of time they have stepped in and they have changed the entire laws. As you quoted that math problem striking to an example, it was actually needed. But then what I would say is that when we actually look into the purpose, whether it has been achieved or not, I think it takes some more days that we have to observe the same. But according to my point of view, the provisions which has been changed or which has been newly culminated or which has been removed or repealed from the act and has been came up as a new act, that is BNS, which we have now. I think that has not come up with that very changes. I think like if it is a progressive measure, it is in hand. We can count it. Like for example, the community service that they have brought in. Like that, lot of progressive changes also we can see, and also we can, if at all, we can see 40% of progressive changes. The remaining 60% we can see the same provisions which remain in IPC. So then, what is the actually what is the thing of making a new law itself? Like it actually sounds like an amendment. Like there are only few insertions, and I don't see the purpose achieved as such, sir. So I think there is a need, but it is not that much change. I think it remains the same. Only few changes have been made effectively.
Okay, thank you. AGRC.
Good afternoon. Myself Kavita Ravi from AGNC. So the question is whether amendment is sufficient. Uh, my opinion is no, because do you know how many times did IPC get amendment? It's more than 75 times. But if it carried, it carried a colonial influence, rather than post-colonial democratic system. And also in a country where we have completed 78 years of independence, is it okay to continue the laws which was made in a way that was designed to arrest and punish our freedom fighters, journalists, and others who raised their voice against British rule? Definitely not, right? Also, we are required not to change, not only to change or include new offences or repeat invalidated offences, but also we are required to change the very objective of the law itself. Uh, because we all know that the objective of IPC is to penalize, that is to punish the offender. But what we are following in our country is reformative theory, which means that uh, our laws should be to reform the criminals rather than merely punishing the criminals. It is rightly said by Mahatma Gandhi that an eye for an eye will make the whole nation blind. So in this line, I see DNS was designed to reflect more victim-centric and reformative oriented system with a strong focus on justice, transparency, and efficiency. Also, one thing which I felt was very good in DNS is they have sequenced the offenses against women and child in order. So, like SAS said, it is not possible to take every offences against women from one place to put it in another place. So, we need amendments. We don't need amendments, but we need structural change.
Okay, thank you. Like that again she pointed out the name of IPC and BNS. So I want to convey you that that philosophy for changing the name. If we talk about the IPC Indian Penal, it means that it's more about punishing the criminals for the punishment. But if we go through the name of Bharatiya Nyaya Sanhita, Nyaya means justice, okay? Bharatiya, Indian, citizen of India, Bharatiya Nyaya Sanhita, okay? So Bharatiya Nyaya Sanhita, it means that in order to provide justice to the citizen of India, Moreover, like victim centered. Okay, like she rightly pointed out. So Bharati Nyaya Samhita talks about in order to give the justice to the Bharatiya, justice to the citizen of India, while Indian Penal Code giving punishment to the people of India. Okay, so no doubt we are at the colonial time. There's a big difference between the English peoples and Indian people. So if we talk about the criminal procedure code, okay, like criminal procedure code, it means that the law which talks about the procedure how you have to tackle the criminal. Okay, that there is a